the hearing in the reference to Baronetcy of Pringle Stichill.
My lords, my lady, you will find in front of you a clip with 4 sheets of paper. Those consist of the cover sheet of Harrison Adulterine Bastardy, which I now hold in the air. May I say that I bought this on Amazon, but I'm told by Miss Page that it's possible to download it in its entirety free on Google Books. Nevertheless, I'm very happy to leave this copy with the board for further consideration.
I must say, it sort of is one of those titles which should be
Yes, how many hits
enshrined in a collection of unusual titles of books.
Well, it is, and certainly when I searched it on Amazon, this was the only result that produced from Adulterine Bastard. In addition, there is page 186, which I think it was Lord Mance who asked for yesterday. There is section 27 of the Data Protection Act, which we'll be looking at because that's needed to put section 35 in context, and it was omitted from the bundle. And finally, there is, as requested, a single-page note in which I've tried to distill the Banbury peerage case.
Very much.
I've done so. It was an exercise in editing. I've kept it purely to the facts. I haven't, by intention, and because I couldn't have kept it to one page if I'd included any of the arguments or the findings. So this is a factual summary.
Okay, thank you. That's very good of you. Thank you.
Can I just to deal very briefly with the Banbury peerage case and what I invite the board to take from it. There are 2 points. The first is in relation to the answers which the judges gave to the questions which were put to them. Then those were accepted as a definitive statement of the law, not only at the time of that case, when the House decided the case in 1813, but well into the 20th century and into the lifetime of Sir Norman. And indeed, I just mentioned in passing that my learned friend has helpfully come up overnight with a case called Watson from 1953, which tends to support that proposition that even in 1953, the court felt bound to approach the matter on the basis of proof beyond reasonable doubt. Of course, for my purpose, it's not so much a question of the standard of proof, it's a question of what evidence is admissible. The second point which I invite the board to take from the Banbury peerage case, and I'm not going to go through this in any detail because we looked at the passages in the speeches of Lord Ellenborough and Lord Redesdale yesterday, but that in my submission they did both find that there was a quasi-limitation rule which could be applied. Now, it's right that they didn't specify a period for that, and it's also right that the period in the Banbury peerage case was greater even than in this case. But there are 2 points which weigh against those considerations. The first is that in the Banbury case, there was not, as there is here, an incumbent whom the claimant was seeking to dislodge. So there was no question of an ostensibly vested right, to use that phrase perhaps loosely, which the claimant was seeking to take over. And the other point of distinction is that in the Banbury case, the claimant and his ancestors had, at least from time to time over the period of 180 years, asserted their claim. So this was not a case which had been allowed, for whatever reason, which had been left asleep for that period of time. So moving on from that, if I may, I will come back, as I said I would, to the passage from Craze on legislation, which is at page 1740 in the authorities bundle, and that is at divider 38 in bundle 2. I looked also at Benyon on statutory interpretation. It seemed to me that the principles were distilled rather more concisely in Craze, but there was no difference in the one aspect of a case, e.g. because it applies to a pre-statute cause of action, may at the same time be prospective in relation to another aspect of the case, e.g. because it applies only to the post-statute commencement of proceedings to enforce that cause of action. And an act which is procedural in one sense may in particular circumstances do far more than regulate the course of proceedings, because it may, on one interpretation, revive or destroy the cause of action itself.
So what do you mean by retrospectivity here? At the moment, where is Section 26 is a question I'm asking myself, but I've got it in front of me on the screen. It doesn't appear to be in the section.
No, my lord, it can be found in the report of the S and McC case at page 1451.
That's a very inconvenient way of doing it. 1451. Anyway, I've got it on the screen. But I'd just like you to tell me, what does retrospectivity mean in relation to Section 26? To what issues and when will it apply?
What it means is that it cannot be applied to the legitimacy or illegitimacy of a person who is no longer alive.
Well, that's a very strange rule. So,
The point is, but this is a simpler point, isn't it? Your initial point is a matter of interpretation. It uses the present tense.
yeah.
Yes.
And therefore, it doesn't apply to a question of whether somebody who's dead was legitimate.
Yes.
It only applies to the present case of whether a live person is illegitimate.
Yes.
Yeah.
And therefore, retrospectivity is irrelevant.
Yes.
Yes, well, that's what
Well, my lord, yes, in that sense, perhaps I can sidestep retrospectivity.
But if it
entirely.
is retrospective, you say it isn't.
I say it isn't, yes. But
if it is, what does it apply to?
I mean, yes.
well,
Is it only people who were born hereafter?
no. It would apply to anyone who was living at the date when the Act came into force or subsequently.
Yes.
So
I see. That's very odd.
Or when the case is being
When
decided.
the case is being decided.
If is
Yes.
means is.
Yes. If is means is, it must be is at the date the point comes to be raised.
Which rather suggests that
yes,
is may not.
I'm
be
sorry.
used.
No, that must be right, of course.
But in that case, you do need your retrospectivity point, don't you? What you say is that it doesn't apply to what legitimacy. It doesn't apply to a case of whether somebody was legitimate or illegitimate if they were born before the Act, or if they died.
If they died before the Act.
Why? Why died before the Act?
Well, because of the terminology of the section, because it only applies to determine whether it's more probable than not that a person is illegitimate or legitimate. If the person in question is dead, then it can't apply.
So what does apply? The old common law?
Yes.
I wonder, is an idea that occurs to me, which may be shot down, is that you might put your argument in this way, that in S, Lord Reid treated, as he put it, the final abolition of the old, this is at page 1454, the final abolition of the old strong presumption of legitimacy by Section 26 shows that in the view of Parliament, public policy no longer requires that special protection be given by the law to the status of legitimacy. Now, so if you're treating Section 26 as signalling a change in public policy, which is then given effect in the common law, then it might perhaps be argued that that doesn't necessarily alter the way in which the common law should treat situations prior to that change, particularly situations in, say, 1903.
Yes, my lord, thank you.
You wouldn't be depending so much on, for example, death. I don't think would come into it. You would rather be saying that it's generally desirable that the legal consequences of situations be determined according to the law in force at the relevant time, and that in a situation where a right is ostensibly vested in 1903 on the basis of the settled law then in force, ordinarily a change in a development in the common law would be applied retrospectively. But if that development is conditional upon a legislative development, which is what Lord Reid's reasoning was, then you might perhaps argue that just as legislation wouldn't be applied retrospectively, as we know from Dunbar, you wouldn't test the legitimacy of somebody in 1903 on the basis of legislation dealing with legitimacy in that case in whenever it was, the 1950s or 1960s. You might try to run a parallel argument.
My Lord, I adopt every word you say, and I don't think I can improve on that.
You might also say, I suppose, that that's particularly appropriate if they're in a situation where most unusually there is no limitation period and there are vested rights.
Yes.
Or vested, I suppose rights begs the question, but there are apparently vested rights.
Yes. So, yes, that too. And could I also...
Otherwise you could reopen inheritances in the 14th century.
Exactly.
Say they'd all gone wrong for 30 generations.
The Richard III situation.
Yeah. Essentially by applying anachronistic legal reasoning.
Yeah, exactly. And could I also come back briefly to the point which Lord Reid raised yesterday about the fact that the blood which had been kept from Lord Moynihan was used in that case. But the answer to that is that it was used to determine the legitimacy of someone who was living. And it wouldn't have been possible, certainly when the Act came into force, and probably at the time of the Moynihan case, to determine the legitimacy of somebody who was dead, because that would also have required a blood sample from that person's father, which is virtually inconceivable. So the fact that the sample was used from Lord Moynihan who was dead does not go against the principles I'm advocating.
It's subject to the point about the role. If this isn't right, would the consequences be that the people who were thought to be the 8th and 9th Baronet never were? And then you would have some pretty startling consequences if you had, the same would apply on the face of it to dukedoms, earldoms, marquisates, baronies, viscountcies. And you would say that in fact, going back for the past 10 generations, for example, they were not, in fact, the people who thought were successive dukes or earls weren't.
My Lord, that must...
And everything they purported to do, why would it have been valid if they hadn't properly inherited?
That must follow, and any steps which they'd taken in relation to family trusts.
In most cases, there'd probably be a limitation defence available.
Yes, but it would still...
But there might be lots of... It might go on for a very long time. There'd be a lot of minorities during which time wouldn't run. In some families, I suppose, insanity.
Have you come up with examples, Mr. Scott, where there wouldn't be a limitation period? I mean, clearly, to the extent that there are property rights which went in the past with some title or other, if Mr. Guthrie's right, declaring 2 centuries afterwards that somebody wasn't the Duke that he thought he was or the Earl that he thought he was wouldn't, I imagine, principally upset the property rights, because the limitation period would normally suffice to preserve the position. But have you? I mean, is that right? First of all, and secondly, have you come up with examples where there would be no limitation period and actions of somebody in the capacity of the Earl of this or the Marquis of that would be at least arguably defeated? Appointments made, I don't know, something of that kind.
Well, my Lord, I will confess I haven't explored this area in detail, and I appreciate, of course, that entailed estates are now unusual, but I explored very diffidently. Yes. My understanding is that in the case of an entailed estate, that limitation wouldn't run, but...
There'd also be quite a lot of equitable rights, and there'd be an argument that legacies couldn't be relied on because until the DNA evidence came to light 10 generations later, nobody knew that they had the right. Something I think I would certainly welcome further thoughts and submissions on in the resumed
Certainly, my Lord.
submissions, because there may be, on analysis, there may be nothing in this, but on the face of it, it's a point that we should examine before we
Yes,
we
well, my
should
Lord,
look at before we leap.
I will certainly do that.
Can I just ask another question on section 26? Does this simply go to the standard of proof?
Yes.
Yes.
Certainly, principally, it does.
Yeah. So the only change is to lower it from a reasonable doubt to more probable. If
It doesn't
was-
have any other effect at all, does it? That's the only thing the statute does, isn't it?
That is, yes, my Lord,
That section.
yes, that's it. Yes,
There's 20 and 21 as well,
yes.
which is procedural.
I'm sorry,
Which are procedural, aren't they?
Yes.
Power to direct blood tests in adults. It's
Yes.
part of a framework which you're entitled to say signals a change in the approach to legitimacy, but
Yes.
it goes back a lot further than 1969.
It does, but of course 1969 was a time of huge overall reform of family law
Yes.
across the board.
Absolutely.
There is one point that occurs to me. It may be an utterly bad point, but since it's in my mind, I'll mention it. The Garter King of Arms, who was pending out of interest yesterday, mentioned to us that there'd been a report by Viscount Sumner, I think, in 1927, I may have recollect wrongly, where he had faced up to this similar sort of problem and had suggested there be a cut-off date of 100 years. Haven't looked up the report. I don't know what it said.
Well-
And it might perfectly well be said, well, that was what he thought was right, but we can't introduce it as a matter of law as a court. But anyway, I mentioned that simply because that's another thing that might be looked at. I'm sorry to be heaping work onto your respective plates, but
My Lord, no, I'm grateful. We have tried to research widely, and Ms. Page paid a visit to the National Archives in Kew to conduct some research, but we didn't come across that.
well, I must say I was completely unaware of it till you mentioned it, and I hope I'm not sending you on a wild goose chase.
No, we will track it down.
Yes.
My Lords, I'm not sure I can take that point any further at present.
Well, I should just
Of course.
raise one point, only really in a sense for information, because I have been reading the Law Commission's report on blood tests and the proof of paternity in civil proceedings. And it has a section dealing with the presumption of legitimacy. And it points out that at the time when they were writing, which is 1968,
Very early law commission.
there was debate about what the common law then was, although most people thought it was that the presumption could only be rebutted beyond reasonable doubt. There was a judgment of Lord Denning saying that following the decision of the House of Lords in Blythe and Blythe that you didn't have to prove adultery beyond reasonable doubt, therefore it followed that you shouldn't have to rebut the presumption of legitimacy beyond reasonable doubt. So I'm just drawing that to your attention. It's there. We'll make what we can of it. But
Thank you, my lady. Thank you.
And can I just mention, in case it's lost sight of, that although I doubt whether it makes any difference in substance, it occurs to me that the question of what law of evidence governs this issue might conceivably be a matter of Scots law,
Yes.
as the lex fori, effectively.
Yes, because we're not sitting in England in that sense at all, other than physically.
Yeah. I mean, I think if you look at it, you'll find that the way the law's developed is very similar, and I suspect the same arguments will apply.
Well, thank you, my lord. That's another aspect we'll look at. So, as I come on to the final case on my first macro issue, which is the Ampthill peerage case,
Yes.
which is at page 1532, divided 24. Now, of course, I appreciate that this case was decided on the basis that of the 1926 Declaration of Legitimacy.
Basically res judicata, effectively.
Basically res judicata, but it does produce a situation which is, to say the least, anomalous, and one might say extremely unfair if someone whose legitimacy was questioned during his lifetime was able to achieve a declaration of legitimacy, which stands as res judicata, whereas somebody whose legitimacy was not questioned during his lifetime, but might have been because there was some query, we know, about the legitimacy, but because he had no sufficient reason to obtain that declaration, he didn't do so, although under the law and the technology at the time, he could have achieved it without any doubt at all. And so that certainly, that may feed in perhaps to the general argument about lapse of time and quasi-limitation, or as a point of general fairness, or as a reason why, although there is that distinction between the present case and Ampthill, it's not a distinction which should weigh too heavily. And
I mean, in other words, in a normal case, you've got the combination of res judicata and limitation. If you don't take the point, even
yes.
though you could, eventually you become time barred.
Yes.
Whereas here, you can just sit back and do nothing for generations,
yes.
it would appear.
Exactly.
Yes, I see. Yes, sorry, what do you want us to look at in this?
I just want to look at a couple of passages. If we can go, please, to page 1554, internal 569. It's the speech of Lord Wilberforce, where he's been dealing, he deals with the Declaration of Legitimacy. But he makes some much more wide-ranging observations from 569A. He says, this principle of finality of determination in the matter of legitimacy is, of course, but one strand in a more general fabric. English law, and it's safe to say all comparable legal systems, place high in the category of essential principles that which requires that limits be placed on the right of citizens to open or reopen disputes.
To open or you rely.
Exactly. I stress, obviously, to open.
Yep.
The principle which we find in the Act of 1858 is the same principle as that which requires judgments in courts to be binding, that which prohibits litigation after the expiry of limitation periods. Any determination of disputable fact may, the law recognises, be imperfect. The law aims at providing the best and safest solution compatible with human fallibility, and having reached that solution, it closes the book. The law knows, and we all know, that sometimes fresh material may be found, which perhaps might lead to a different result. But in the interest of peace, certainty, and security, it prevents further inquiry. It is said that in doing this, the law is preferring justice to truth. That may be so. These values cannot always coincide. The law does its best to reduce the gap. But there are cases where the certainty of justice prevails over the possibility of truth. I do not say that this is such a case, and there are cases where the law insists on finality. For a policy of closure to be compatible with justice, it must be attended with safeguards. So the law allows appeals, so the law exceptionally allows appeals out of time. So the law still more exceptionally allows judgments to be attacked on the ground of fraud. So limitation periods may exceptionally be extended. But these are exceptions to a general rule of high public importance, and as all the cases show, they are reserved for rare and limited cases where the facts justifying them can be strictly proved. And then just following on from that, he says that I've emphasised a little length because counsel attempted to minimise the declaration of legitimacy. But then at F, Lord Wilberforce continues, think only of the position of Mr. Geoffrey Russell, declared the lawful son of his parents in 1926, treated as documents show for the purpose of family settlements as legitimate, having married and founded his own family on the assumption of legitimacy. He is now, after 50 years, when both his parents and probably other contemporaries of his birth are dead, to have his status questioned, to be graded as some kind of fictional issue which cannot rank as lawful issue or qualify as such under the terms of the grant of the barony. This cannot be the law. If ever there was a case for closing the chapter in a family's history, the case for closing this in 1926, after the distressing revelations and divisions over so many years, must be one.
After all, Geoffrey Russell was declared. I mean,
yes.
The fact is that this statutory provision enabled someone whose legitimacy was challenged to apply himself. I don't say that there was any cause, but there might have been. It seems to me it's a different situation.
My lord, it is a different situation, and I recognise that
Yes, you said
at the outset. But I do say that
But it's quite difficult to know what you're asking us to derive from it then. What are we to do? To devise a similar bar, but based on what?
well, my lord, based upon the other arguments which I've addressed you on the lapse of time, on the undesirability of declaring somebody a bastard posthumously, which we say is the law, but
That's the hard point, is it? I mean, that's where you fix the limit. You say that there can never be a challenge after someone's dead.
yes,
So you have to challenge the first wrongful claimant.
yes, I do. And I mean,
So if he dies after a year, that's the end of it. If he dies after a year, that's the end of it. Or for 10 minutes.
Yeah, it's got to follow. It's got to follow.
Well, yes,
If that's your position.
that must follow.
It's
But
But you can have a looser doctrine like the doctrine of lay cheese, can't you?
well, yes, but of course late cheese can be excused. So I considered late cheese, but we haven't relied on late cheese for that reason. Because
The problem
obviously,
about late cheese is there was no basis for making the claim until the DNA was obtained.
well,
Would that be fair or not?
well, I wouldn't say there was no basis because we are told that Ronald always believed that he was the right.
Well, that's not a basis.
Well,
You can't turn up in court and say, I believe that's my position.
Well,
we're also told that the trustees of the 8th Baronet distributed the family heirlooms to the second son, aren't we?
well, my lord, we are told that, but the evidence in support, we haven't touched on that. The evidence in support
No,
of
but
that is
there-
extremely weak. All that the
but-
evidence actually shows is that certain of the chattels came to the second son.
I'm sorry, Mr. Scott, I thought it rather helped you.
I'm sorry, my lord.
I'm sorry, Mr. Scott, I thought it rather helped you.
Well-
in demonstrating that there might at least have been cause to challenge the succession of the
Well-
9th Baronet.
My lord, I don't want to look a gift horse in the mouth, but there was certainly some thought. We know that there was. We know that the whether or not Murray was told, he says he wasn't told, but it appears that Ronald did tell other members of the family. Yeah. So we know that Ronald believed this himself. He could have raised it. If he had raised it in any forum, Sir Norman could have applied for and obtained a declaration of legitimacy.
Yes, I mean, the late cheese is something of a two-edged weapon, isn't it? Because if late cheese is available, then maybe that's an answer to all the points we've been considering. And if late cheese won't run too bad, you say no, because with the development of science and the change in the approach of the common law, unless we find something other than late cheese and limitation doesn't work, you will have the problem that we've been discussing, or the problems we've been discussing.
Yes, but what I'm saying is that if you take the principles underlying late cheese and limitation.
But you're expressly not relying upon the doctrine of lay cheese, is that right?
Well, my lord, I'm saying that I haven't relied on the doctrine of late
But
cheese.
you're waiting until the next case? Or?
Well, my lord, no. But in the light of the invitation which has been extended to consider that aspect further, then I wouldn't want.
Well, Mr. Scott, as we're going to come back almost certainly, and certainly going to have further written submissions, if you want to argue late cheese, then you better make your case. Mr. Guthrie can consider whether he opposes your right to argue it at all, and what his position is on it. But we better leave it for the moment.
Yes, my lord.
Well, so long as I have an opportunity to deal with it.
Oh, yes,
Yeah.
that's very fair, Mr. Guthrie. Thank you. Thank you.
And you might want to think in this question about whether the general idea that developments in the common law apply retrospectively may be qualified, may benefit from further thought. The leading case that occurs to me is Bentley, but that's in a completely different context, where you look at a situation in the past, ignoring changes in statute law since then, but taking into account developments in the common law. But there, there's no prejudice to any vested right or ostensibly vested right involved And that's not dealing with changes in the common law which are consequential upon statutory innovation, as Lord Reed explained the changes in S to be.
My Lord, I'm afraid that the name of that case didn't jump.
Derek Bentley. It's a criminal appeal. It's to do with retrospective application.
Of course.
How you judge situations in the past relative to the law of the present day.
Yes, well,
Let him have it, Chris.
Yes.
Yeah.
yes, of course.
1998.
Thank you, my Lord.
Yes.
Then, my Lord, briefly going on to the speech of Lord Simon of Glaisdale, which starts at page 1560. At E, there's another slightly surprising comment that as a means of resolution of civil contention, litigation is certainly preferable to personal violence, but it's not intrinsically a desirable activity.
A typically colourful phrase.
Yes. And, but then going down to letter G, there is a fundamental principle of English law, generally expressed by a Latin maxim going back to Coke, which can be translated as, it is in the interest of society that there should be some end to litigation. This fundamental principle finds expression in many forms. Parliament has passed statutes, the latest only last year, limiting the time within which actions at law must be brought. Truth may thus be shut out, but society considers that truth may be bought at too high a price, that truth bought at such expense is the negation of justice. The great American judge, Justice Story, delivering the judgment of the Supreme Court of the United States in Bell and Morrison, called the first of these acts of limitation.
I'm sorry to interrupt. Could you just give us the reference, the page you're reading from?
Yes, I'm sorry, my Lord.
No, it's not your fault.
It's 1560, starting at G.
We've got to the bottom of the page, virtually.
Thank you very much, Simon. Yeah, sorry.
I mean, we do know what statutes of limitation are about.
My Lord.
You say this is in the context of this very type of case.
Yes, and just on the next page, 576.
Late cheese.
It refers to late cheese. It says the courts of equity, originally set up to make good deficiencies in the common law, worked out for themselves a parallel doctrine. It went by the technical name of late cheese. Courts of equity would give relief only to those who pursued their remedies with promptitude. Then people who have long enjoyed possession, even if they cannot demonstrate a legal title, can rarely be dispossessed. Then goes on to say, Scottish law goes even further than English law. Delay in vindicating a claim will not only bar the remedy, but actually extinguish the right. Well, perhaps with hindsight, that should have put us on notice. But there we are.
Yeah. I mean, that may, when you come to it, that will have implications for your argument. I mean, effectively, if prescription operates, is the right of the stirps extirpated, rather than it being merely a bar to a particular claimant personally?
Yeah. Thank you. It also raises an interesting question. I mean, supposing you believe, as my Lord says, but you can't prove something, and you say, and then with the development of science, suddenly becomes that the proof becomes available and it becomes realistic to litigate or to claim. How does late cheese operate in that sort of situation?
Exactly. That's the question. That is the question.
Of course, I now feel I perhaps didn't look into late cheese in sufficient detail.
Well, we look forward perhaps to a further analysis of the law late cheese.
I might look at Lindsay Petroleum and Herd, I suggest. It's a good start.
It's more.
I'm sorry, my Lord.
Lindsay Petroleum and Herd is a good start.
Thank you. However, I don't think...
It would also be worth, sorry to make things more complex, but it would also be worth, when you are getting Scottish advice, assessing whether late cheese has anything to do with it at all, or whether the defence of mora, taciturnity and acquiescence might be the relevant doctrine.
I think, if I may say so, that sounds a more promisingly correct line to look into than late cheese for the reasons we discussed. But nonetheless, it's worth making the point that any decision we make much of it will apply to English titles.
Yes.
Yes.
And therefore we would be assisted by that. And as often happens, the Scottish and English approaches, although going under different names and adopting slightly different principles, that tend to arrive at the same answers.
My Lord, yes.
I remember using the word estoppel in the Scottish employment tribunal once, and being an objection being raised by counsel on the other side that no such doctrine existed, whereupon the chairman leant forward and said, I think Mr. Mance will find that the doctrine of preclusion is precisely the same as the doctrine of estoppel. So,
Well, Scottish lawyers tend to know more about English law than English lawyers know about Scots law.
I think we can agree there.
And I think we've had ample demonstration.
I was just going to say, I've
Across
just
the last day and
demonstrated
a
that.
bit.
My Lords, I don't think that at this stage I can add anything
Thank you.
on the first macro issue,
Right,
so I pass
okay.
on to the second one.
Second macro issue is very different in nature, yep.
Very different in nature, and which I think I can probably take more briefly, because we are only concerned with two relatively modern cases,
Right.
both of which I suspect are quite well known. I think it's perhaps convenient to look first at...
Can you remind me what the second macro issue was? Because I only wrote down the first one.
Oh, right.
On the basis that you were going to come back to the second one.
The second is whether, assuming that Murray would otherwise be entitled to rely on the DNA evidence, he should nevertheless be precluded from doing so because of the misuse of private information issues, to use a short
That's what I thought this was all about. I don't know what the micro issues are.
Well, my lady,
Let me not distract you.
Micro issues have been developed under the cloak of the macro issue.
Yeah.
So
well,
far.
the micro issues are they are confidentiality, privacy, Article 8 of the European Rights Convention, and the Data Protection Act.
Okay. You say there are two authorities you want to take.
Yes, if we can look at Campbell and MGN, which is in divider 3, page 808.
Thank you.
As I say, I think I can assume this is more familiar territory than the Banco Peerage case.
Much fun. Not after yesterday. Yep.
But this is the case which, in our submission, and I don't think there's any dispute about this, is really a convenient starting point for the modern law of misuse of private information. And of course, the present case is very different from the Campbell case, because in the Campbell case, what the courts in the House of Lords were concerned with was a balance between Naomi Campbell's right to privacy under Article 8
Yes.
and the Mirror newspaper's right to publish under Article 10.
Yes.
So to that extent, there's a balancing act which arose there, which was at the heart of that case, which simply doesn't arise here. But nevertheless, there are some general statements about the law, and I think we can perhaps go straight to speech of Lord Nichols at page 816.
Thank you.
At paragraph 16,
Yes.
he refers to the convention and says that the provisions of Article 8 concerning respect for private and family life and Article 10 concerning freedom of expression and the interaction of these two articles have prompted the courts of this country to identify more clearly the different factors involved in cases where one or other of these two interests is present. Where both are present, the courts are increasingly explicit in evaluating the competing considerations involved. When identifying and evaluating these factors, the courts, including your Lordship's House, have tested the common law against the values encapsulated in these two articles. And then at paragraph 17, the time has now come to recognise that the values enshrined in Articles 8 and 10 are now part of the cause of action for breach of confidence. As Lord Wolfe has said, the courts have been able to achieve this result by absorbing the rights protected by Articles 8 and 10 into this cause of action. That's A against B. Further, it should be recognised that for this purpose, these values are of general application. The values embodied in Articles 8 and 10 are as much applicable in disputes between individuals or between an individual and a non-governmental body, such as a newspaper, as they are in disputes between individuals and a public authority. And then that's repeated towards the bottom of the page. And then briefly looking at Lord Hoffman's speech, which starts at 820. But perhaps going to paragraph 46 at 823. Right. In recent years, however, there have been two developments of the law of confidence, typical of the capacity of the common law to adapt itself to the needs of contemporary life. One has been an acknowledgement of the artificiality of distinguishing between confidential information obtained through the violation of a confidential relationship and similar information obtained in some other way. The second has been the acceptance under the influence of human rights instruments, such as Article 8 of the European Convention, of the privacy of personal information as something worthy of protection in its own right. And pausing there for a second, one point which we make in our case is that in the present reference, then the position is, if anything, a fortiori, because by pressing Sir Stuart to provide the DNA sample, Murray did assume a relationship of confidentiality. And then at paragraph 51, Lord Hoffman says this: the result of these developments...
Did he promise? Did he not say that it would be available to everybody who was part of the project on the website? Did he not make that clear?
No, my lady. What he said was that he didn't say that. As I understand what he was saying, because some of it is quite technical, what he was saying was that the results would be fed into the website, which would be available. He said that he would have access to the individual results. But, of course, the individual results, the specific relation, they would not be available to other people because the results would be anonymized. And indeed, if one looks at this website or comparable websites, that is how it's done. I'll be coming to the facts in a moment, what he did, what we say he did and didn't do. Then the final sentence of paragraph 51. Instead of the cause of action being based upon the duty of good faith applicable to confidential personal information and trade secrets alike, it focuses on the protection of human autonomy and dignity, the right to control the dissemination of information about one's private life, the right to esteem and respect of other people.
You say he impliedly agreed not to use it for any other purpose.
Yes. And we say that that is reinforced by the Data Protection Act.
Yes.
But, I mean, the example which I think was used, I think, in the earlier case, the spy capture case, where the House of Lords considered whether the duty of confidentiality, a pre-existing duty, was required, and they used the example of someone coming across a piece of paper containing confidential information which was blown out of an open window. And what we would say here is that if Murray had come across this information by pure chance, he would still have been under a duty of confidentiality in respect to its use, because it was plainly inherently confidential information.
But he didn't misuse the DNA. What the most you can complain about is his current or subsequent use of the knowledge which he derived from the analysis of the DNA. And that was knowledge which surely he was entitled to publicize in this sense at least, that he and those running this project were avowedly intending to identify the head of the clan, and it would be obviously necessary to disclose the results of the DNA to demonstrate that the head of the clan was not the person who, on the face of it, would appear to be the obvious person, because he seems to come from the senior stirps. So to that extent, I mean, you're really complaining about someone having knowledge and using it. You're saying that, as I see it, I can't see there's been misuse of the DNA, which was what was handed over and what is the first object of confidence. You have to be complaining about the use of the knowledge which was acquired, and he can't prevent himself getting the knowledge once he sees the results of the DNA test. He has the relevant knowledge for the purposes, or for all purposes.
Or do you say it's using the DNA test rather than his knowledge of it for the purpose of this litigation?
Yeah.
I see. Yes, I mean, his knowledge of it, if he no longer had access to any proof of it, if all he was saying was, I have seen DNA evidence which shows that, he wouldn't get anywhere. It's the fact that he is able to rely on the DNA analysis.
Yes, but that's the knowledge derived from the DNA rather than the DNA itself, isn't it?
It is the information.
Yes, the information.
It's the information which he has obtained. But as my lady said in the House of Lords, in the case which I'll call MARPA because it acquired that title in Europe, nothing is more confidential than a person's DNA profile.
Well, that's what I'm putting to it. It is not actually, because this would be a profile which would inevitably be required to demonstrate that, contrary to the apparent position, in fact, Sir Stuart was not entitled to be the head of the clan.
Well, to that extent, Sir Stuart had consented to its use.
Yes, but in publishing that, he's bound to publish the reason.
Well, my lord, no. With respect, all that would have needed to be said was that that samples taken from this branch of the clan did not show a sufficiently close relationship. Samples taken from another branch of the clan were more cogent in establishing the chieftainship. It would not be necessary.
How could that happen? I mean, the only way in which it could happen would be by effectively saying that this branch of the clan was not descended from the 8th Baronet.
No, because it could and should have been kept anonymous so that individuals could not be identified.
And what if someone said, look, Sir Stuart is the obvious person. This is the senior branch of the clan. Why isn't he claiming, or why isn't he recognised?
Let's take a hypothetical case. Suppose that Sir Stuart had said, I don't accept this, and I insist that I am entitled to be the head of the clan. At that point, Murray would have been entitled to bring the data out of anonymity in order to prove the point. But as long as Sir Stuart accepted it, then he was entitled to retain his anonymity, and all Murray was entitled to do was to point to somebody else as having a stronger claim to be the head of the clan.
Right.
The point, my lord, is that the use of the data, the confidential data, to challenge the baronetcy was fundamentally different in nature to the use of the same data for the chieftainship of the clan.
I mean, the other argument is that this is a balancing exercise, even if you're right, because on the one hand, it's being used, assuming it's accepted, to get it's proving something which is true, which otherwise couldn't be true, through a court. And there must be a public interest, whether it's brought within Article 6 or not, isn't the central point. There is a balancing exercise, isn't there? Or do you say there isn't one?
My lord, I say there isn't. That is the argument from section 35, which I'm going to come to.
Well, it's a more broad brush approach. Surely there is an interest in getting the truth, assuming that it does establish the truth which otherwise wouldn't be established, and assuming that the truth is going to have consequences. You say there's no public interest which needs to be balanced against your Article 8 rights.
My lord, certainly not in the circumstances of this case.
I see.
I mean, it might be possible to imagine cases where there was, but not here.
I see.
Doesn't the Crown have there's obviously a public interest in dignities and titles of honour. The Crown having granted them, the Crown might have an interest in them going to the right people.
Well, my lady,
The Crown Office is sitting in this room.
Why are we here, in a sense, might be.
Yes.
Has it not been referred to us as a matter, because it is a matter of, to be treated as one of public interest?
It's not a purely private issue, this.
My lady, it's not a purely private issue, and of course, if this were a peerage rather than a baronetcy, then the element of public interest would be greater.
But even if this was a private issue, there is still an interest in getting to the truth.
Yeah.
But as my lady says, there are wider issues here.
Well, what I had been intending to do was to take the board briefly to Immerman,
Fine.
and then to come back to consider the facts and also to look at the data protection.
Okay.
Before you do that, can I just get back to a point 2 or 3 ago? What use then was made of the DNA on the issue, who should be the chief of the clan?
Well, from the last time I looked at the Clan Pringle website, that issue has still not been resolved. So I can't say in detail. I don't have the technological
So
skills.
the whole point of taking the DNA was, on the face of it at any rate, in order to use it in some way in deciding who should be the chief of the clan.
Yes.
He has been, according to the papers, the trustees, quite what their status is may be interesting, but the trustees of the Clan Pringle have recognised Murray as the senior representative, as the head of the clan. So I think there is a resolution to that point. It's somewhere in the papers.
Well, perhaps you could get...
I think it's in the agreed statement of facts and issues in the chronology.
In that case,
Is that right?
I think it's in the chronology attached to the agreed statement of facts and issues.
Yes,
Clearly
that's what I
something
thought,
don't
yes.
know.
Yeah. Well, I mean, on that basis,
And the work, I mean, if you look at the list of DNA, I won't go to it, that's enough, I think, probably.
You seem to help me.
Which paragraph is it?
It's at the very end of the chronology, 27th of June 2014.
Where's the chronology?
I mean, it's attached to the statement of agreed facts and
Is there
issues.
Which page is
Page
it?
455.
We
Page
don't have a
459.
chronology.
Yes, we don't have one, right.
Oh, it should be at the end of the statement of facts, agreed facts and issues, at page 459.
Perhaps it is in the back.
we've got the statement of agreed facts and issues.
But
Which
no-
paragraph is it in that?
Well, it's in the chronology which is attached to the end of it.
Yes, page 459.
Page 459 electronically.
Well, I don't have any
We don't have.
Well, we don't have hard copy of the chronology to which you refer.
Well,
For some reason I do.
I can only apologise for that. I think Lord Hodge has.
Well, Lord Hodge is privileged, yes.
My page 451.
459, my lord.
459.
I haven't got a page 459.
No, we haven't got that.
Yes, I see it on the screen.
Okay, right, well, that's why Mr. Scott didn't notice. Okay.
Is it the 27th of June 2014 you were invited?
Yes, it is. That was when the Clan Pringle Association resolved to support the application's petition to the Lion Court.
Okay,
Yes. Right, thank you.
thank you.
And was the petition to the Lion Court to be recognised as clan chief, I take it?
Yes, but it's held in abeyance pending what is happening now.
I see, so the Clan Pringle Association resolution to support means the resolution was passed.
Yes.
Yes, thank you.
And where's the petition?
Well, we haven't got the petition in the bundle.
I expect
Well, it
somebody
might be
can
of some
find
interest
it.
to look at the petition.
Okay. Right, Mr. Scott.
Well, I think then I was right to the extent of saying that the chiefship of the clan has not been determined, if only because it's being held in abeyance pending the outcome of these proceedings.
Yes, but the answer to my question is that the DNA was a critical, the outcome of the DNA was critical in the decision whether or not X should be the chieftain of the clan, wasn't it?
My lord, yes. I mean, that was the purpose of obtaining
Right,
it.
the whole point of it.
And that was what Sir Stuart consented to. But my point is that it was, so far as the use of that DNA data is concerned, it is a wholly separate purpose to use it for the
Why
present
aren't they all? Isn't that a slightly Alice in Wonderland aspect of the case? Because surely it's all bound up together.
Well, no, because the passage that we've just
Look at page 429 to 430, which is the page I had in mind, about the paragraph 30 of the applicant's witness statement. Inaugural meeting of the clan, charitable status. One of our missions is to identify a clan chief through the surname project and support his petition to the Lord Lion. Then resolution in 2013 by the trustees that neither Sir Stuart nor his descendants were eligible to be nominated chief of the clan because the project results showed that he was not related to the Pringle of Stichill lineage. Consequently, the trustees accepted my nomination as chief of the clan. So,
yes,
I mean that deals with the point of that.
yes. But my lord,
And that's not an issue, is it?
no, that's not an issue.
And doesn't that link with Lord Clark's point? The two are interlinked, aren't they?
Well, no, my lord, they are interlinked if you look at it from Murray's perspective. But what the board must do in our submission is to look at it from Sir Stuart's perspective, because it was his confidential information which was being used. And he was entitled to give his consent for its use for a specific purpose, which he did, but not for any further purpose.
But it's implicit in that, in the use of Shirley, in that consent, that it will be used for the other purpose. It's all part of the same.
Well, my lord,
question.
with respect, no, it isn't. And the way to test that is that if somebody had said to Sir Stuart, well, you do realise that since he'd raised the question of a cuckoo in the nest, you do realise that if this shows that there's a cuckoo in the nest, it might therefore show that you are not, that you shouldn't be the baronet.
Well, the fact it didn't occur to him, or may not have occurred to him, isn't the point. One has to judge this objectively, what he gave his consent to. You can't say, well, I didn't mean what I objectively agreed to, if he agreed to it.
Well, my lord, the question is, what did he agree to?
Yeah, exactly.
And what he agreed to was the use of the material for the search for the clan chief.
And what Lord Clark's putting to is that really the distinction is unreal. To say, well, I was prepared to let it go that far, but no further.
Well, my lord, with respect, it is not unreal. It is absolutely crucial to the person in Sir Stuart's position.
Yes, I see.
And that if one applies not merely a purely subjective test, but if one asks the reasonable person test, would a reasonable person in the position of Sir Stuart have regarded consent to the use of the DNA for the search for the clan chief as incorporating or leading to the use of the DNA to bastardize his father, then the answer is plainly no.
That's a very dangerous point, because if one asks oneself, what would one advise, or what would Sir Stuart, an objective, sensible person, not necessarily a lawyer, but advise Sir Stuart, they would have said, well, look, you do realise that once you provide your DNA, ... If you test it that way, then that's what he was agreeing to. It all depends how you put it.
Well, my lord, with respect, I think it would have been extremely difficult for anybody to advise Sir Stuart to that effect.
Is this right, Mr. Scott? If we look at Murray's original letter
Yep.
to Sir Stuart, page 31,
Yep.
Does it follow from that that the chieftainship had not historically been coincident with the baronetcy?
Well, it certainly suggests it, and there is certainly nothing...
Clearly not, because the last recorded chief was John Hop Pringle of that ilk, died 1738 without issue. He isn't one of the baronets who'd been started in the 17th century.
Yes.
So it isn't a case in which the baronetcy necessarily, or rather the chieftainship necessarily went with the baronetcy.
And
As the remainder of the letter, it's not necessary to read it out, demonstrates. On the other hand, does it follow that if, as seems to be alleged, the result of the DNA test was to demonstrate that the general wasn't a Pringle at all, that would not only disqualify him from being, that would disqualify him from ever being chief, wouldn't it?
my lord, it
As
would.
well as, as is now alleged, disqualify him from being the baronet.
It would, yes.
So what was the purpose then of taking the DNA test?
Well, the
For
purpose
the purpose of deciding whether or not he was, or anybody else was, could be the chief of the clan.
Well, no, the purpose was to decide whether, among a number of possible contenders, of whom he was one, he had the closest relationship to the previous chief of the clan who died in 1738, who, as my Lord Hughes has pointed out, was not the holder of the baronetcy.
And if he had no relationship, as it turned out, what then? That must have been a possibility, obviously, and a possibility for anybody, alas.
Well, in that case, he would be excluded from being clan chief, but it would not... It could hardly have occurred to him that he would be excluded from being the baronet.
Really?
Why isn't it plain as a pikestaff?
Well, I mean,
He mentioned himself, didn't he?
Yes.
well, he mentioned the possibility of a cuckoo in the nest.
Yes.
But
Well, what was the cuckoo in the nest? It was somebody in the nest who was a cuckoo, the nest being the baronet's nest,
Page
Pringle's
36.
net.
or the Pringle's nest. Yeah.
well, but my lord,
Was he or was he not a cuckoo?
well, can I take it a step back? First of all, if the chieftainship and the baronetcy were necessarily coincidental, there would have been no need for the DNA survey because it would have been, Sir Stuart would have been entitled to be proclaimed chieftain by virtue of the baronetcy. So it was plain that the two were not necessarily the same.
So what use then was the DNA?
Well, what the DNA...
On the clan point.
As I understand it, the use of the DNA was to establish the relationship, Sir Stuart's relationship, not to previous holders of the baronetcy, but to the previous last chief who died in 1738, which is not by any means necessarily the same.
How on earth was it going to do that? It's a Y chromosome DNA test only. It only works for. It's not it doesn't identify an individual. It identifies as it were, a male inheritable characteristic. Nobody's got anything from John Hop Pringle of that ilk. How on earth was it going to do what as a matter of interest? How could it ever do what Murray was suggesting?
My lord, I'm afraid I don't understand.
Unless it showed he wasn't a Pringle at all.
And he talks about, in his own letter, he talks about tracing his ancestry back to the 15th century. And then the same letter talks about a cuckoo in the nest. Now, alas, for his point of view, sadly, he was the cuckoo, it would appear, on the DNA evidence. But that's all encompassed in his letter.
Well, my lord,
And
I stand on the point that consent to the use for one purpose was not the same as consent to the use of the other.
Understand.
I don't accept that introduces an Alice in Wonderland element.
Understand.
Because in my submission from Sir Stuart's point of view, these points were fundamentally different.
Okay.
And I submit that it was incumbent upon Murray to ensure that a proper consent was given. And indeed we know, because my learned friend told us yesterday, that Murray himself realised that this was a separate point, and he pondered the situation for 4 months before he decided to write the further letter which he wrote about the baronetcy. He knew that this was a separate issue.
okay, right. Now you wanted to. We were about to go, I think, to another case.
I was going to go to Immerman. my
Yes, thank you. We found that in tab 10 of bundle 1.
Yes, thank you. Page 1092.
Thank you. Yeah, thank you. Yes. Yep.
And of course, this was, on its facts, a very different case, because the facts briefly were that in the context of a divorce, the wife's brothers did not trust the husband to give full financial disclosure.
Wasn't concerned with admissibility of evidence, was it?
Well, it does, indeed, the judgment does touch on the admissibility of evidence.
Shows that one doesn't.
And we can perhaps go straight to the end to have a look at that.
Okay.
Starting at page 1151.
1151.
Yes.
Thank you. Yep.
Under the orders.
Yes.
But then at 170, paragraph 170, 1152, the court said this: after all, the use in court as evidence of material which has been improperly obtained, whether in breach of confidence, tortiously, or even criminally, is permissible, though such use may be refused by the court or permitted only on terms. Subject to certain exceptions, notably information obtained by torture, the common law does not normally concern itself with the way evidence was obtained when considering admissibility. See Sang and Kuruma. Accordingly, in the present case, it appears to us that information derived from the documents obtained, albeit unlawfully, from Mr. Immerman's computer records is, subject to the questions of privilege and relevance, admissible in the ancillary relief proceedings. However, just because it is admissible, it does not follow that the court is obliged to admit it. It appears as a matter of common law, a judge often has the power to exclude admissible evidence if satisfied that it's in the interests of justice to do so. Where the civil procedure rules apply, the position is even clearer.
I interrupt to remind you and myself that we are looking at English law here, and of course...
My lord, of course, everything I say, I'm afraid, must be subject to that. But it held that the court did have power to exclude evidence. In my submission, that must apply equally to this board on the reference under the 1833 Act.
Yep. Yes.
And I would say that, as the board knows, an application was prepared for an injunction to restrain Murray from using the evidence. So Stewart's statement was prepared for that purpose. He clearly felt very strongly about the way in which the evidence had been, as he saw it, misused. But in the event, because of his declining health and his death, that injunction wasn't pursued and those proceedings fell by the way.
Well, it'd be a bit odd for a court to grant an injunction restraining evidence being used in the judicial committee. It'd be a matter for us.
Well, of course, my lord, that's precisely why we didn't, why there's no question of an injunction.
Quite.
But what we say instead is that, rather than an injunction, that the court's power is to prevent the use of the evidence, and that's the appropriate way forward.
You were saying we should exclude it. I understand that.
The test is the interest of justice.
Well, yes, because there are a number of public interests here. There is a wide public interest in using the phrase in the non-legal sense in genealogy. It is desirable, it's interesting for a lot of people to pursue genealogy. If it becomes known that a DNA sample which is given for neutral genealogical purposes can then be used against the interest of the person who has given it without any further consent being given, that is going to damage the lawful pursuit of genealogy. And that is an important public interest. And that is perhaps the key point here as to why the use is different, because Sir Stewart made it clear in his letter that he was completely neutral about the chieftainship of the clan. If anything, he was slightly concerned about taking it on. He certainly didn't care if the DNA evidence established that he was not the chief of the clan, but he did care a great deal if it established that he was not the lawful baronet.
Yes.
So that is the difference. It is taking information which has been given for one purpose which is neutral and then using it against someone's interest.
Yes, I see.
Can I mention, when you do look at the Scots law or obtain advice about it, you look at a case called Imrie against Mitchell, which is in 1958 session cases, It's to do with it's a case where the Inner House considered that evidence of blood tests were inadmissible to establish paternity. But it was because the blood had been taken from the purported father without his being told he had the right to refuse, and it had been taken from the child without anybody qualified to give consent, consenting on the child's behalf. So it was a pretty strong case on its facts, but it indicates that in principle, evidence of that kind might be incompetent, even though it's relevant.
Thank you very much, my Lord. We will certainly look at that. So far, again, as English law is concerned, and probably also Scots law, we would suggest that there is an important public interest in not allowing DNA evidence to be used for unauthorized purposes. Much DNA can now be obtained from a single hair. And it is surely against the public interest that somebody should be able to take, say, a hair which has fallen from somebody's head onto their clothing, and use that without permission to disturb apparently established paternity.
Is it a question of degree, though? I mean, is it a question of judgment, as my Lord was putting a moment ago?
Well, my Lord, in the end it must be a matter of judgment, because I am saying that the evidence, I concede on the basis of Immerman that the evidence is in principle admissible. I say it should be excluded. So to that extent, yes, there is. It is.
I mean, there are two questions. One is whether there was any breach at all of privacy law, and the other is whether, if there was, it's of such a nature that one should exercise the discretion, so far as one exists, on these authorities to exclude it.
Yes, I accept that, my Lord, that's right.
But what's the interest now being pursued, the private interest now being pursued? Because obviously this information is, as a result of these proceedings, very much in the public domain.
Well, yes, it is. But that
so the private interest must be the retention of the title?
Well, the private interest is the right not to have the established lineage disturbed.
Yeah.
And there is, we say, contrary to learned friend submissions, that even the deceased Sir Norman has an interest, I'll avoid that word, has an interest, a proper interest, in not being declared illegitimate 60 years after his death.
Yes. Yep.
And insofar as there is a public interest in establishing the truth, there is also a public interest in not disturbing well-established lineages because of the damage which that could cause, not so much in this case, but in other cases, could cause to families.
Coming back really to the first point, but it applies to the second point as well for the reason you give. Yes, I see. Yep,
yes.
Thank you. Thank you. Yep.
Well, Lord, I think then I can turn and I think...
Data protection, or...
Perhaps finally to the Data Protection Act.
Thank you.
Now, and that is in Bundle 2 of the Authorities, Divider 28, page 1616.
Thank you.
And I think it's fair to say that nobody claims that this is a particularly easy or accessible statute.
Right. Sort of introduction that suggests we're about to have an intellectual treat. Sort of introduction that suggests we're about to have an intellectual treat. Yes. Anyway, what you wanted to look at, Mr. Scott?
Well, I'd like to spend a little time going through this, because one does have to look at the scheme.
But your basic proposition arising out of it is what?
My basic proposition arising out of it is that in addition to the use of the DNA data for the present purpose being a breach of Sir Stuart's right not to have his private information misused, that it was also a breach of a duty which Murray owed under the Data Protection Act.
Under which section in the end do you rely on? Just so
Well, the public, statutory duty, which was referred to in Immerman, because this Act, of course, was touched on in Immerman, is in Section 4.
Yes.
Yeah, for
Yes.
Duty to comply with the data protection principles.
Yes.
Which principle are we concerned with?
Well, my Lord, we are concerned with the first principle.
And that's page, I think it's, yeah. I think the principles are, I think, set out on page 1640, aren't they? Or 1639.
Yes, thank you.
And the first principle, sorry, that's interpretation of the principles. I do beg your pardon. The principles are on page 1638.
Yes.
Yeah.
Personal data shall be processed fairly and lawfully, and in particular shall not be processed unless at least one of the conditions in Schedule 2 is met. But we need, my Lord, to go back and consider what processing means, because processing has a very wide meaning.
Means almost any use.
Yes, any
Yeah.
use.
Yeah.
Yes.
So,
Okay, so that's very quickly, which section is that?
so that is Section 1
Yep.
at the bottom of that page. Processing in
Yes,
relation
thank
to
you.
information or data means obtaining, recording, or holding the information or data, carrying out any operation or set of operations on the information or
Yes, I
data,
see.
including, little b, retrieval, consultation, or use of the information or data.
Fine.
So even if a person has data in his
Yes,
knowledge,
Using it.
using it is a further processing.
Okay.
And each such further processing has to be consistent with the principles, including
Okay.
the first principle.
And you say, so far as the first principle is concerned, really for the reasons you already canvassed, apart from any other point you're going to make, it's not fair.
Yes,
Yep, okay,
it's not fair.
understood.
And we say indeed that it's not lawful.
Because it's in breach of Article 8.
Yes. And of course, we have to remember that Murray hasn't only, I mean, he's used his knowledge, he's used the DNA data in quite a widespread way. He's notified a number of other members of the Pringle clan to try to enlist their support for his cause. He's notified, arguably, he might have been entitled to notify the Standing Council of the Baronetcy. But even if he was entitled to use it for his own litigation purposes, which we dispute and will be coming to in a moment, he certainly wasn't entitled to broadcast it around the world to his family and the wider members of the clan.
Right, okay.
Then if we look at Part 2 of Schedule 1, the first principle says, in determining for the purposes of the first principle whether personal data are processed fairly, regard is to be had to the method by which they are obtained, including in particular any person from whom they are obtained is deceived or misled as to the purpose or purposes for which they are to be processed. Now, we are not saying that Murray was planning ab initio to use the data for this purpose, although plainly Sir Stuart became suspicious that that was the position, but we're not advancing that case. But what we do say is that what this means is that during his 4-month period of reflection before he embarked on his claim for the baronetcy, he made a decision to process the data further, and that for that purpose, Sir Stuart had been misled because he had not been told and was not invited to agree to the use for that further purpose.
Yep.
Now, my learned friend relies on the exemption in section 35, which for some reason appears after that. It is at page 1653.
Yes.
But in order to put Section 35 in context, we need to look at Section 27, which was the section which was provided this morning.
Section 27, yes.
Yes.
That's on a separate piece of paper. You
That's
gave
on
us
a
this
loose
morning.
piece of paper, I'm afraid.
Thank
yes.
you. No, that's... Yep, thank you. Yep,
Because if we can have, if I can invite you, please, to have Sections 27 and 35
Yes.
together.
that's the advantage of having it separate, yes. Thank you.
Yes. Section 35(2), on which my learned friend relies, says personal data are exempt from the non-disclosure provisions. So to consider that, we need to look back to Section 27, subsection 3, which says in this part, the non-disclosure provisions means the provisions specified in subsection 4 to the extent to which they are inconsistent with the disclosure in question. Then subsection 4, the provisions referred to are the first data protection principle, except to the extent that it requires compliance with the conditions in Schedules 2 and 3. Well, I have to say I have wrestled with this because the first point to be made is that if one looks at the first data protection principle, as we were, it's not actually concerned with disclosure. It's concerned with processing and use.
Well, disclosure is a form of processing.
Disclosure is a form of processing, but in any event, but it further says that there is an exception to the exception where Section 27(4)(a) specifies except to the extent to which it requires compliance with the conditions in Schedule 2. So if we can go to Schedule 2, please, which is at 1645.
Yes.
And paragraph 1 is, the data subject has given his consent to the processing. So that appears completely to emasculate the apparent effect of Section 35.
The conditions in Schedule 2
Yes.
are not cumulative,
No,
they're
no.
alternatives.
Yes.
So that's not the only condition
No.
on which disclosure is possible.
And you've got 5A.
Yeah.
Well, there's also 6.1, which is the
Yes.
broadest of the
Pursue.
omissions, yes.
Yes.
Goodness knows what that means.
But, of course, we then have to consider whether for the purposes of those provisions, or for the purpose of Section 35 itself, whether the use can truly be said to be necessary.
There's an awful lot of law on this, you know.
Well, my lady,
Some of it at this level, lots of it at the tribunal level.
I did do some research
Something of a
on this.
minefield.
But it, as far as I could see, the law really related to the use of information by public bodies, which seems to give rise, although obviously it overlaps.
Not necessarily. I mean, a lot of these data protection principles have been considered in the context of freedom of information requests. Now, those obviously do involve public bodies, but private data controllers are just as subject to the Data Protection Act as public ones are.
Well, that,
Otherwise, you wouldn't be raising this point at all.
of course, because we say that that Murray should have registered with the Commissioner.
Yes, probably should.
But, my lady, confessing my ignorance, but whether the use or disclosure is necessary must be specific to the facts of each case.
Sounds right.
And we say that it cannot be said that it was necessary in this case.
Well, how do you test necessity?
Well,
there's a Supreme Court decision saying it means reasonably necessary.
So, well, reasonably necessary, but reasonably necessary for any purpose? Or?
Well, for the purposes which are
particular
permitted.
case, yeah.
Yep.
Is there any case which deals with the effect of breach of the data protection principles in terms of evidence or any exclusionary rule about evidence?
Well, so, I mean, Immerman does to some extent. We can go back to look at Immerman.
You're guilty of an offence if you're unlawful. Are you unlawfully obtain or disclose? Section 55. But what about unlawfully processing?
Yes, I think we do have section 55.
Yes, on page 16.
We do, but that's unlawfully obtaining.
Or disclosing.
Yes, but not.
Yes,
But it's knowingly or recklessly.
Yes.
So you have to...
Well, of course, this is a difficulty because this section 55 starts with a person must not knowingly or recklessly without the consent of the data controller. And it doesn't really address the position if it is the data controller himself who, as we say, was misusing the information. But, well, what I say is that, albeit that there is a public element in this case, there is also, at the heart of it, a private element. The private element is Murray's wish to become the baronet. And it would give him the benefit of a circular argument to be able to say, I wish to become the baronet, I have obtained information under one guise, and it is therefore necessary for me to be able to use that same information for a purpose for which no consent was sought or given.
Yep.
Because that, of course, I'm wary of Floodgate's arguments, but one has to consider what the consequences would be if anyone were able to do that. The Immerman case was a special position because the information, the documents had been obtained before the husband had had the opportunity to give the financial disclosure which he was required to give. But in a case, in a situation such as the present, where there would have been no obligation on Sir Stuart or anyone else to give any DNA sample, then it is, as I say, it is begging the question to say, well, I've got this information and it's necessary for me to be able to use it.
Yes, I think that section 55A of the Act empowers the Commissioner to impose a monetary penalty for a contravention of section 4.4, which requires compliance with the data protection principles.
Yeah.
Yes.
It doesn't make it a criminal offence, but it's a penalty imposed by the Commissioner.
No,
It was added in 2009.
But section 4.4 was treated in Immerman as imposing a statutory duty
Oh, yes.
on the data controller.
Yes, but there doesn't seem to be any, originally there doesn't seem to be any sanction for breach, but that was added in 2009. Yep. Yep. Very well, thank you.
Well, I'm not sure, my lord, that there's anything further on which I can help at this stage.
Thank you very much indeed. Anything else?
I'm sorry, can I just ask one matter that occurs to me? I think you say in your in your written submissions that that the domicile of the people we're dealing with here, those who are dead, isn't known. Is that common? Is it common ground that we proceed on the basis that we can't tell the domicile?
Well, I did wonder about that, and on further reflection on looking at some of the documents, it does appear that probably even the 8th Baronet at least, was domiciled in Scotland.
Right.
Where does that appear?
Well, he made a Scottish will, didn't he?
Yeah.
He made a Scottish will.
Yeah.
Well, perhaps at that point, which, given that we're going to have written submissions, you can deal with it in writing. Hopefully you can agree on the answer to Lord Reed's question, but if you can't, then you better put in brief submissions dealing with what you say and why on it.
Yes.
Yeah.
Yes. Well, thank you.
Yeah. Thank you.
Thank you very much.
It's a will drawn up by David Hope's grandfather.
Thank you very much, Mr. Scott. Thank you. Mr. Collins.
Yes, and he says it's a self.
Thank you very much.
He says it's new all himself.
My lords, I'm not quite sure how best this hearing should now proceed, because my learned friend has...
Well, you obviously better deal with the second macro point to take.
Well,
Mr.
if I
Scott's
can,
submission.
my lords, certainly...
On the first point, well, to some extent, it's a question of using your judgment.
yeah.
I don't know if there's anything you want to say about the Banbury.
Well, I have one or two things to say about it. My worry is that it may be that there will be further things to say on reflection.
Yes.
On the basis that you don't, I get the impression that you feel our time and your time and Mr. Scott's time would be better served if you dealt with it in writing.
Well,
The first macro point.
I hadn't intended to give the impression of ducking it.
No, I wasn't suggesting you were.
But, Lords,
If there's anything you feel, I think we must leave it to your judgment. If you feel it's better dealt with, and your sense of fairness, in the sense that if there's anything Mr. Scott should if there's sensibly anything Mr. Scott should fairly know about now, given that he's developed some of his arguments. Well, it's a matter of judgment, I appreciate,
yes.
but I think we were content to leave it to your judgment about how much, if at all, you deal with the first point now.
Well,
if on reflection you feel there are one or two things you should have said and Mr. Scott should have notice of, you can let him know. You can let him know in writing,
yes,
exactly.
Well, Lord, it certainly struck me when looking at the Purbeck case and the Banbury case that we are dealing with historical situations which proceeded in, well, the one thing one could say with any certainty is that at those times it was quite impossible for paternity to be proved or disproved, which is now something which can be done
Quite.
through the use of DNA sampling. And it seems to me that one is stating the obvious as to that. But if one looks at the way in which those cases were developed, part of the ratio for them is indeed the fact that paternity cannot be proved.
Well, you don't have to go back that far. You find Lord Simon making the point.
Well, exactly. But when I was, it's an expression I don't like, the elephant in the room, but the fact is, it was quite impossible at that stage to establish paternity or indeed to disprove it. And if one looks at the cases themselves, I think the Purbeck case, which my learned friend referred you to, we see the principal passage at page 1232.
Thank you.
Which tab is that?
It's tab 13.
Yes, the penultimate
The passage
page.
which he read to you.
Yes. We have Littleton on dissents.
Yes. Well, before that, if you like, the judicial outrage is the attempt to show that his father
was begotten of his grandmother. This ought not to be endured. And item 1 is filiatio non potest privare. Nec debit, in other words, it can't be established, nor ought it to be. And then the other matters, talking about item 3, he hath been found heir to the land and son of the grandmother by a special verdict in 1635, when matters were more capable of proof, witnesses being since dead. So of the reasons for the rule, if it can indeed be elevated into a rule, which we would respectfully doubt, 2 of them have been extinguished by the advances in scientific evidence.
Well, in a way, 3 is the Amtil peerage point, isn't it? Oh, no, it isn't. It isn't. Well, no, it probably is a slightly...
Well, it is a similar point, because there was indeed a special verdict.
Anyway, your point ultimately is that all this has been overtaken by...
Well, exactly. And if one looks at the Banbury case, which...
yes.
is at page 541, I think.
Thank you.
It's the first of the
yes.
cases. One shouldn't...
this is the choleric report of...
Yes, well, the case itself, of course, it's all about whether or not one can establish who the true biological heir is. I mean, that is, as I say, the question which is being...
Yes.
If I can just... yes, I'm sorry, I've got the wrong bundle open. That is the basis for the judge's answers, which one finds in the first short report under Vida 1.
Yes.
The tenor of the answers is that at page 542, at the top of the page 63, the internal page, the judges are unanimously of opinion that the presumption of legitimacy arising from the birth of a child during wedlock, the husband and wife not being proved to be impotent and having opportunities of access to each other during the period in which a child could be begotten, in the course of it, may be rebutted. A little further down, in the middle of the page, such prima facie evidence of legitimacy may always be lawfully rebutted by satisfactory evidence that such access did not take place. The mere physical fact of impotency or of non-access or of non-generating access, as the case may be, may always be lawfully proved by means of such legal evidence as is strictly admissible in every other case in which is necessary by the law of England. And it is said that these matters were within the competence of a jury. But the purpose of the judge's answers to the questions is that this can be established. The only reason why there is a wrinkle to that is because at that date it was futile, where there was more than one possible father, to decide which one it was. And that is the basis for the separate rule of evidence, that one cannot go into questions of the husband and the wife, or if they were having intercourse with one another, that was not the intercourse which led to the birth of the child, but some other adulterous intercourse was. Looked at in that light, the Banbury, one wonders what the position would have been, for example, if a child was born to a couple in the early 19th century, who quite plainly could not possibly have been the child of the father who was married, for example, if it was a completely different race, for example, what the effect of this would have been.
But the reason for the rule that a married couple must be assumed to be the father of a child during the marriage is because of the impossibility of proving otherwise, and for no other reason.
Yes, they don't address that question.
They don't address that question, but it's one which certainly occurred to me.
Yeah.
In the court, there were one or two short passages in the judgment. Indeed, before one gets to the judgments,
Yes.
if one goes to page 704, the electronic page, one sees the Attorney General, Sir Vicary Gibbs, opening the matter and professing to be entirely disinterested in it as a Minister of Justice. He says, I draw my deduction from a series of circumstances in the contact of Lord Bunbury, Lady Banbury, Lord Vaux, Nicholas Vaux, etc. Your Lordships must recollect the position in which I stand. I come here in semi-judicial capacity without any other object than to secure the triumph of truth. And a little bit lower down, the question is not whether any of the circumstances I have stated are adequate to prove the illegitimacy of Nicholas, but whether, on the whole, the claimant can make out the legitimacy of his ancestor. If I deny that he was legitimate, it is not incumbent on me to show negatively that he was not the son of Lord Banbury, but the onus is on the claimant to show that he was, and also to show that the claim has not been extinguished, either by the former proceedings in this House or by the length of time during which it has lain dormant. And there had, of course, been the previous hearing, or rather, I think, inconclusive hearing in 1661, which the Lords referred to. Lord Ellenborough's judgment at page 709, internal page 456, this is when they're framing the questions to which they suggest they should give the answers. These propositions embrace a variety of points too extensive for application to this case. There's no doubt the presumption of the legitimacy of a child.
Sorry, where are we?
709. There is no doubt, says Lord Edinburgh at that stage, that the presumption of the legitimacy of a child, the husband and wife having access, may be rebutted. In this case, there is no proof of the access of the husband and wife. The question, therefore, is whether the presumption of access can be rebutted by any circumstances. This is the abstract point to be ascertained. Until we separate the law from the fact, we shall never arrive at a just conclusion. The fact is to be tried as facts are tried before a jury. The law may be decided on reference to the judges. I certainly think it desirable to have the opinion of the judges whether any circumstances can rebut the presumption of access, and then a question arises whether the circumstances in this case constitute such circumstances. Lord Eldon says, I certainly agree with the noble Lord on the expediency of putting this question to the judges. When the law is once settled, there will be no great difficulty in deciding on the evidence of the fact. I do not conceive non-access, or what the noble Earl Stanhope terms non-generating access, is to be presumed because the Earl of Banbury was 80 years old. Swinburne says that the possibility of issue must not be applied to a case where the husband is 80, but he is corrected by his annotator, who observes that to this general doctrine, Englishmen of 80 formally protest. I think an opportunity for considering ought to be afforded to the House. Lord Erskine again says, I recommend the propositions to be put in the shape of questions to the judges.
We've seen what the judges, what we looked at earlier.
Yeah.
Which is what the judges said. Were they the judges answering these questions, or were
Yes, they were. Yes, they were.
So these are the questions to which they were answering.
Yes, but the way in which they were framing it were to provide some help to the future as to how the presumption of legitimacy could be rebutted. And they drew the line at a point which the, if you like, science reached at that date, which was you couldn't have a child by your wife if you were not in the same country and had no opportunity of access to your wife. And you couldn't have I think the example is also given of someone with the absence of the generative parts. But that was about it. so far as they were concerned. It is not a secure foundation for saying that there was a public policy in the presumption of legitimacy being preserved for all purposes. In fact, the presumption of legitimacy was, they were effectively identifying the means by which it could be overturned.
I see. I know that Lord Redesdale didn't want to refer it to judges, but gets another rebuke in a footnote. But anyway, that's by the way. We can analyse what's said in this case till the cows come home, I think.
Yeah.
Yep.
Well, there's,
is there anything else in this case you want?
well, I was going to just refer to the passage. Well, the history of it was, of course, that again, there's an echo of the Ampthill case, because the matter had come before the Lords back in 1661. And one sees at page 736 that had also been before the House in 1692. They treated the resolution then passed as deciding the right and concluding the question. In the view of the King of the House, and as acquiescence goes of the claimant, the resolution was considered as conclusive if the proceedings in this House are liable to be invalidated on such slight grounds. The House is little entitled to the appellation of a Supreme Court of Judicia. And then...
Well, where was that?
At the bottom of the page.
That's at page 736. And then... page 738, the House is governed by laws analogous to the laws of the land. It would be absurd that the acquiescence of the successive claimants in the successive express and implied rejection of a claim did not impeach the validity of such a claim. In law, the failure to bring a matter before a jury when the memory of the transaction is fresh raises a strong presumption against the right, and it is the duty of a judge where a statute of limitation does not apply to point out to the jury the force of the presumption. In a case where the statute does apply, he should lay a stress even on suspense. An enjoyment for a length of time may create a presumption against the Crown, so non-enjoyment for a length of time may create a presumption in favour of the Crown. Yes. Suppose an information or intrusion filed in 1661 in which the court had not thought fit to proceed, and accordingly no verdict is given on the case. Another of the information of the same kind is filed in 1692, and a verdict is given thereon against the Crown. A third information is filed in 1727. Would not the jury have told the Crown that the neglect for so long a period created the strongest presumption against its right? Independent of any other part of the case, I think lapse of time is sufficient ground for rejecting this claim. And this is the passage which your lordships saw yesterday. But all that is being said is that it creates a strong ground of presumption. Lord Hardwicke, it said, thought that the lapse of time coupled with the previous proceedings in the House was conclusive against the claim, even in 1727. Who can question what he would have thought in 1811? And it's at that point that Lord Redesdale says, I feel perfectly confident that had I been a member of the House in 1661 or 1692-3, I should have opposed the claim. That is not the same as saying that here I am in 1813 applying the same spectacles as I would have been wearing in 1661 to the decision.
Yes, I see.
And indeed, that isn't the effect of the decision. Lord Ellenborough says very much the same thing. But if one looks at his judgment from the top of page 741, the descendant of Nicholas Vaux is now endeavouring, after a feverish period of 180 years, to establish the legitimacy of his ancestor. The sole question before the House is whether Nicholas was the legitimate son of William. It's been urged with great force by a noble and learned lord that the very remote date of the cause of this discussion is alone fatal to the claim. The case is of such a size and of so peculiar a nature that the technical rules followed in other courts of law should be applied to it with caution. Yet in the absence of precedents, I am disposed to adopt the sort of reasoning upon which all statutes of limitation are founded. The arguments have been objected as fallacious because they rest only on presumption. All cases of this kind must be governed by the presumptions arising from the fact of marriage. The presumption in favour of legitimacy is sometimes strong, often weak, sometimes irrefragable. But being a presumption alone and not a rule of law, it is liable to be repelled by circumstances inducing a contrary presumption. Let a man live with a woman as if they were husband and wife, let them have children, let the access, let the production and the recognition of children be proved. If evidence could be given that he had not the organs of generation, all this would go for nothing.
Yes.
It is always open to discussion in the civil law whether the supposed father was in fact the father. If the child was born on the wife, vere sua hoc ignoranti, sit in domo susceperit. Bracton and Fleeter both show that these principles were clearly introduced into our own law, and in the reign of Edward I, a child was declared illegitimate, notwithstanding the coverture and cohabitation of its mother and ostensible father. The presumption of real issue is always open to discussion. And he says, it appears to me, and I trust on an attentive examination of the proceedings in 1661, it will appear to all the House, that the committee had little doubt that Nicholas was illegitimate, but they felt themselves bound by a known rule of law which had till then been acted upon, but which ought to have been held null. I would respectfully suggest that the case is very slender authority for a rule excluding evidence of paternity, or excluding evidence to disprove paternity. Yes. Indeed, it's rather the opposite. The judges were concerned against, I think, the popular will of some of their peers to establish Nicholas Vaux's legitimacy. In answering the questions, they drew the line where history, so to speak, required them to at that stage. But it isn't possible to say they did so on the basis of the law in 1661. Lord Erskine's conclusion is at page 767.
Now, do I understand correctly that of the reasoned judgments, they all agreed apart from Lord Erskine?
Yes, well, yes, I understand it, yes. And Lord Erskine, he said that he considered that the opinion of the law entertained by the committee in 1661 was well-founded, that Nicholas, the original claimant, ought to have been admitted to the full enjoyment of the privileges of this earldom. The same rights have descended to the present petitioner, and I trust they'll be recognised by your lordship. He's not saying that you are bound by but by what happened in 1661.
Yep.
In Lord Eldon's judgment, he says, upon an accurate review of the evidence, it would seem that from the death of the Earl of Banbury in 1632 until 1661, nothing had transpired to make it probable that Nicholas Vaux had a right to the earldom. Your lordships must therefore place yourselves as if you stood in the House in 1661. Had we then been called upon for our opinion, I think that it would have been impossible for any of us to declare Nicholas to be the son of the Earl of Banbury. I mean, all he's really saying is that the situation was the same in 1661 as it is now. But it isn't authoritative, the proposition that the lordship should somehow, in 2015, approach the matter as though you were sitting in 1990 on the death of the 8th Baronet. Or that you are bound by an outworn rule of evidence. Well, there's my learned friend sought really to bring this principle of nothing being admissible, which tended to contradict the legitimacy or paternity of a child where the husband and wife were living together as man and wife, right up to 1969, I think, when the Family Law Act was passed. But in reality, it does not seem that that was the position, or that it was impossible to rebut the presumption of legitimacy at any stage. The case he relied on, Gordon and Gordon, which is the one which your lordships saw, relies in turn heavily on the passage from the Adulterine Bastardy book.
Yes.
That, in fact, I won't ask you to look at that again. It's the one in which has the quotation, doesn't matter, 1, 10, 20 or men in it. It was considered in a subsequent case, which I found overnight, which I thought your lordships might like to see, called Watson and Watson. And also I've shown to my learned friend, in fact, he referred to it in passing this morning. It's perhaps a demonstration of the rather unsatisfactory nature of the presumption. It's reported in 1954, volume 1 of the probate reports, or the probate reports. And it's a decision at first instance of Mr. Justice Barnard.
Thank you.
And the issue was the paternity of a child born to a wife, more or less during the war, I think. The head note reads, an allegation in a husband's petition that he does not admit the paternity of a child does not stop the wife from claiming maintenance for the child after a decree has been granted to the husband on the ground of her adultery, although she did not specifically raise the question of paternity either in an answer to the petition or during the hearing. And it's the facts are set out in which the husband said he'd been using contraception, and the wife said that she did. Well, he said the wife had admitted that the child was probably not his. And if I just ask you to note at the bottom of page 49, at the end of the argument, or at the end of the recital of the facts, prior to the hearing, the wife had refused a request on behalf of the husband for a blood test to be taken of the child. And Mr. Justice Barnard found that the husband was a truthful witness, that the wife was not a truthful witness, and at the foot of, well, it's summed up on page 53 of the report, second paragraph from the end. The fact that I entirely believe the husband and completely disbelieve the wife does not, unfortunately, decide this issue. What I am dealing with here is the legitimacy or illegitimacy of a child, and the law is very strict about these matters. The law is just the same today as it was at the time of Gordon and Gordon. It's true that the facts were very different, but Sir Francis Jones, President, lays down the law on this particular subject and then sets out the passage which you're familiar with. It's true that since 1903 the use and knowledge of contraceptives has become much more common, etc. He says, I'm satisfied that the wife made all these statements. I don't think that they are sufficient to rebut the presumption of law in favour of legitimacy. It has been, and he says on the last page, the only other matter I think I ought to mention is the question of a blood test. Once again, I don't think that carries one step further. It ought not to count against the child, and it's the child's future I'm considering. It only shows what a thoroughly evasive woman the wife is. Having heard all the evidence, I've come to the conclusion that if I had to decide this merely on a balance of probability, I would decide in the husband's favour, because he is obviously so truthful, coupled with the wife's statements about the paternity of the child. But in face of the presumption of law, which means that he must satisfy me beyond all reasonable doubt, I feel that he has not displaced the presumption. I therefore decide the issue in favour of the wife. Well, that doesn't suggest that the presumption is irrebuttable, or that if he was confronted with the sort of evidence which is available in the form of DNA, he would have reached the same conclusion. In fact, he plainly would not have done, because he would have found that the father's case was decided beyond reasonable doubt. And while it's perfectly true that in the present case, if the issue had come before a judge such as Mr. Justice Barnard in 1919, the incumbent, if I can call him that, would plainly have won the day. He would certainly not have won the day on the law if the evidence was admitted to the standard which is now available.
So if you can rely on the current state of the evidence, assuming you win on the second
Yes.
macro
Yes.
point, even if the law to be applied is that of 1919, you say you still win.
Yes, I would
Understand.
still win. Yes.
Thank you.
It simply is not an irrebuttable presumption.
Understand.
The learned friend says that.
Thank you. Is there anything else you want to say on the first macro point?
Well,
at this stage?
subject to coming back.
No, at this stage.
Yes, I don't think there is, no, my lords.
Thank you very much.
On the second issues in relation to breach of confidence and the Data Protection Act, I think I take a rather broad brush approach, and I don't make any apology for it, because on the facts of this case, which your lordships have now seen in detail, it would not be fair to find any malign or devious intention on the part of my client in what took place at all. And it would not be fair to say that the basis upon which the DNA was obtained from Sir Stewart was not with his full agreement and with a full knowledge of the facts as they existed at that time. It seems to me to be quite wrong to suggest that everything changed as a result, as the results came in. And I would respectfully agree with a number of the observations put to my learned friend that it must have been perfectly apparent at all times that what was being dealt with was a matter of lineage. It was apparent to Sir Stewart that it was a matter of lineage. It was spelt out in the letters that it was a matter of lineage. It was spelt out that the results of the blood test would be available to my client as the data administrator, and that they would be used, they might be used in a submission to the Lord Lion in support of his application to the chieftainship of the clan. And indeed, in the correspondence, it must have been entirely clear that the reason that Sir Stewart was, so to speak, being referred to throughout as the most likely contender was because he was head of that branch of the Stichill family, which indeed my client said, this is also my branch, and it would be an honour for my branch of the family if your position as head of our branch was vindicated and you became chief of the clan. And I would respectfully say there was nothing unfair at all in what happened, nor indeed was there any breach of confidence. But I don't think, I mean, your lordships are aware of all the matters which we say support that conclusion. If it is wrong, and there was an unintentional breach of the Data Protection Act, which I would respectfully submit any lay person might be forgiven for committing, that is hardly a basis for excluding evidence which is required in the interests of justice, as we say it is in this case. And it is a right which the applicant has under the law of hereditary succession to be enrolled as the baronet. And it's in the public interest, has also been observed in the course of argument, that baronetcies are recorded in the names of those persons who are entitled to the baronetcy. And in that case, the evidence in the DNA sample is conclusive because it shows that Murray is a person, and indeed the only one of the two contenders, who can bring himself within the terms of the original grant. And I come back to our basic proposition that that is the question which your lordships are required to determine. The reference is who is entitled to be enrolled as baronet. The only person who is so entitled is the person who comes within the description of the original grant, which is my claim. And that is how the reference should be decided. My lords, I would be perfectly content to leave it at that point now if...
Well, can I just ask you, you've slightly... I take your point that you have an argument, even if you're right, if you're wrong about the under the Act. But what do you say is the position under the Act? Are you conceding that there was an error or breach of the
Well, Lord, no,
or not?
No, I'm not. I'm not, because I'm not conceding there was a breach of the principles under the Act as to fairness. And I do understand that use and so forth can be regarded as a part of processing. But I don't concede that there was any breach of the principle concern.
What you're saying is, A, there's been no breach under the Act, but B, if there has, it shouldn't be a reason for denying you your...
And indeed, if any balancing exercise which has to be carried out must come down in favour of the truth, and indeed in favour of the lawful right.
Just in a sentence or two sentences, I follow that's your ultimate position. But what is the basis in 2 or 3 sentences why you say there's no breach?
Because it was not unfair.
Yep, it complied with the first paragraph 1 of the first schedule.
Yes, I don't think the breach that's put against you is confined to the complaint that it's unfair. It's rather more precise than that, isn't it? It's disclosure beyond...
Well, what I would respectfully suggest that the analysis, so to speak, attempting to draw a wedge between the receipt of the results and the transmission of the results to the Lord Lion and other persons, and saying that the character of what was taking place changed at that stage, so that if the obtaining might be fair, but the use, which we say was contemplated in any event, was unfair, is unrealistic. What one's looking at is one particular matter, and it is a stretch and an over-technical approach to regard, to separate out the two aspects of the matter and suggest that the breach of Part 2 is a breach where the obtaining and the use were, in fact, allied together in the consent which was originally given.
I understand you say, apart from Section 35, the use is fair, bearing in mind the correspondence.
Yes.
And the provisions of Schedule 2 are satisfied because of 5A and also
and 6.1, yes.
Okay.
And but I would say that the correspondence is not confined to the obtaining.
Understand.
It also envelops the use.
Well, I understand.
And we would say it's really unfair to us to say that we were somehow precluded from using or disclosing the material when it proved to be not to be to Sir Stuart's liking, when he would have made absolutely no complaint at all if he had got the right result and we sent it off to the Lord Lion, as we originally intended and indeed wanted to do, to establish him as the chief of the clan, as the leader of our branch of our family.
Okay.
You want to satisfy Schedule 3 as well as Schedule 2?
We weren't taken to Schedule 3.
Yeah.
Well, this is sensitive personal data.
Well, it isn't, is it? Is it? I wondered about that. I mean,
Section 2 is sensitive personal data. I'm not sure if
it does. I'm not sure it's
under
it's suggested, but I mean, it might be the nearest is what? Physical condition? That's not really.
No.
I think it would.
Racial or ethnic origin is not quite. His sexual life we're not looking at.
Well, I think at one point in the correspondence he does reserve his position as to whether it is that, but I would suspect it's not.
certainly the other side have suggested, albeit perhaps tentatively, that it is, but I
Well, you
wonder...
can still bring it within the paragraphs of Schedule 3, you can bring it within, so I don't think it's a problem, but
But just tell me on a different point.
interpretation.
Yeah. I mean, we're proceeding on the premise that this is data within Section 1.1. Just a matter of interest, which subsection of 1.1?
May I just have a moment to tell you up?
Which what?
Subsection of Section 1.1. It's 1616. It is.
Yes.
I mean, it probably is A or B, but we don't know, do we? Whether it's on a computer. It may be C, a filing system, part of a filing
Well, it
system.
must be recorded somewhere. It's a bit difficult to see.
Yes.
But
But it's presumably there must be some filing system to keep the records, one would have thought. Even it's probably on a computer.
Yes. Well, the situation is slightly complicated in this case because one is not dealing with one data administrator or data controller because there can be more than one under the Act. And of course, the persons who retained the material are not Murray, but the DNA heritage people subsequently taken over. And the correspondence shows that they maintained that they complied with all the requirements for keeping.
Yes, but you
become a data.
You become one. That's right. When you're given the information for the Pringle
They
clan.
both have the information.
Yeah.
But they know, yeah.
okay.
But, well, I'm sorry, I just took one point out of my mind. I'll see if I can try and retrieve it.
Sorry.
That's my fault, because I introduced Schedule 3. Not for the purpose of making trouble, but because
no, well,
if,
it may
which I
occur to
believe it is, it's sensitive personal data, you've got to also satisfy.
Well, I mean, it's no
But you
part of
can.
our it's no part of our case to say that DNA is freely usable by anybody for any purpose. What we say is that the information we gave encompassed.
Well, I think Mr. Scott's point is this, that if people know that by giving a DNA sample, if it proves something unexpected and unpleasant, it could result not merely in their being exposed to the revelation that they're not quite who they thought they were genetically, but that they may get deprived of honours, titles, property, who knows
Well,
what.
we say that
And that's
is
the
really
wider
not,
public interest point.
that is not really this case because as my Lord Clerk said, Sir Stuart was perfectly well aware that what he was doing was giving his DNA for the purposes of establishing a lineage.
Well, that would apply
It
in
really
any-
doesn't bear any comparison with the situation of a man who comes across somebody's hair or steals a hair.
No, his point is genealogy research. You could say that in any case where somebody is asked to give their DNA. That's his point.
Well,
In the context of genealogy, and
well, if they're asked in the context of genealogy, surely they must be aware that the results are not necessarily going to be favourable to them. And it's unrealistic to say that it was a purpose of obtaining this DNA when nobody knew what the purpose might exist at all. It's a little unfair, too, with respect for my learned friend, to say that you can make some kind of inference that my client was in breach of the Data Protection Act because he waited some 4 months before doing anything about it. It seems, with respect, the much more likely inference from that is that he was rather concerned at the results which he'd received and appreciated that they were likely to cause some distress to Sir Stuart. Well, my lords, I think, unless there's another matter relating to that, I would probably be more focused in my remainder of my reply in writing.
And the petition, we don't have the petition to Lord Lowe.
No, I will try and get hold of that, my lord.
We could have that.
I've made a note to do that.
I guess.
Yeah.
Good. Well, then, thank you all both very much, and thank you also for those who prepared the written cases. We will meet again almost certainly on 25th January. I say almost certainly because it's conceivable, but I'd have thought unlikely almost to the point of impossible that the written submissions will clarify things to the extent that oral argument will be pointless. If either or both of you feel oral argument would be pointless, can you let us know? Because we will be proceeding on the basis that there will be a fairly full day's hearing on the 25th of January.
Yes, well, certainly we will.
And you have the timetable for the exchange of submissions.
Yes,
and counter-submissions.
18th of next month, 14th of January, we will certainly be careful to pay it. And also, I should remind your lordships that we have undertaken to provide you with a colourful family
Yes.
tree. We did copy it, but unfortunately it got left behind. But we have it and we'll provide it.
Well, thank you all very much indeed then. Unless there's any other matter arising, we'll resume again next year. Thank you very much. Court's now adjourned.